Be seated. Are we ready for the jury?
Yes, Your Honor.
Very good. Let's bring them in.
Yes, Your Honor.
Your Honor, the jury is present and seated.
Welcome back, members of the jury. Mr. Schaub, you may proceed with your rebuttal argument.
The sanctity of life. That's kind of what he started with. The sanctity of life. Reading those words and how important it is, the sanctity of life. Well, let me tell you something. This isn't Marquise McLaughlin. It's not. It's a body on an autopsy table. Marquise McLaughlin, on the morning of the 19th of July, when he was breathing, a live individual whose life is important, was a father. He had a mother. He had a dad himself. He had children. Objection, Judge. Overruled. He was a human being in our world. And is the taking of his life worth that? That is the injury that he lost his life over. Think about it. What have we come to in this country? Same objection, Judge. Overruled. What this case is all about is plain and simple. The Second Amendment, fine. You know, there's certain things in this world people shouldn't do. The toughest thing I ever had to do with my mom when she was alive is tell her she couldn't drive anymore.
I'll sustain the objection. Let's not talk about personal things, but you may proceed.
A person who can't drive anymore. Not everybody can drive a vehicle. Not everybody should drive a vehicle. One of the greatest things in the world is having children, right? I mean, it really is. But not everybody is capable of being a parent. We see that every day. The military. It's great that people want to be in the military, but you know what? Not everybody should be in the military. The Second Amendment. It's been around forever. It's a great thing, fine. The NRA, fine. But carrying a concealed weapon, fine. But just because it's there doesn't mean everybody should be involved in that. That fella right there had no business ever having a gun. No business. That's what this is all about. He had no business operating a firearm. He didn't know what he was doing. And they want you to say, well, he might have not received the proper training. Or, okay, he didn't know exactly what the 21-foot rule is. Well, you killed somebody because of the 21-foot rule. You should know what it is, because you took the life of another human being. Isn't the value of human life more important than that? Think about it. Think about it. If you're going to operate a firearm, if you're going to have a carrying concealed weapon permit, and not just have that permit, but carry a sidearm around on you every minute of the day, you better know how to use it, when to use it, and when not to use it. You don't put yourself in the position that he puts himself in with a firearm. You just don't do it. And that's why, you know, that first evidence, the Williams Rule evidence, that's why that was important. After that, he should have known better. What did we learn from that? He thought, as a result of an altercation, a verbal altercation with another human being, that he could have blown his head off. Think about that. Think about it. What have we come to in this world? I can blow your head off. Same parking spot, same situation. No, you can't. He thought it was okay to monitor that parking lot. No, it's not. He was told by the store owner, knock it off. It's not worth it. I don't want you doing this. And what did he say? And that's why that stuff was so important. He was already scolded for doing the same exact thing. And what did he say? Remember, he said, I know I can't help myself. It always gets me in trouble. Is that the fault of Michael? Or the father's name is Michael, so sometimes we make a mistake by saying Michael. Marquise, Martin, McLaughlin? No, it's not. It's not at all. That's not his fault. That's his responsibility. He's going to be a man carrying a gun. He's going to be a man toting a gun around. Remember where this was, when this was? This was in broad daylight, in a parking lot in Clearwater. A parking lot in Clearwater, broad daylight, a place he goes every day to get his 4 or 2 monster drinks or whatever he gets. Broad daylight. We're not talking about some deserted street in the middle of the night, some alley where nobody's around. We're talking about broad daylight? In the middle of a day? A place you're always at? Where people are coming in and out? You gotta have a firearm on your side? All right, I know it's legal, but certain people shouldn't be doing that. He's one of them. He's not responsible enough. We know that. We know that by his statements. And those statements are so compelling, what he said. It's just so amazing what he said when you think about it. The officers are like, what are you doing going up to people's windows? And the defense all along goes, well, he didn't know there was 2 children in that car. And guess what? He didn't know there was a lady in that car. Well, that's the problem. You don't go up to people's cars and confront people if you don't know the situation. Guess why? What if it's an elderly person in there? What if it's a person with a heart condition? What if it's a lady who's in pregnancy? What if it's a mother with 2 babies in the car? 6 months and 3 years old. Marshawn and Marley in that car with Brittany. You don't put yourself in that situation. Mr. McLaughlin didn't start this confrontation. He did. He started it. No one else. He wants to play parking lot monitor with a firearm to his side. Totally wrong. That's not right. That's not Brittany's problem. He is. What is she to think when she sees some crazy guy walking around the car, walking in the front, walking in the back, looking in the windows? She's got 2 babies back there. My God. What is she to think? How is she to feel? Well, we know one thing. You know, one of the basic things we learn, first-year law student learns in law school. Don't ask a question you don't know the answer to. Well, Mr. Trevina got up there, and remember Vicki Conrad? He asked her, well, he wasn't threatening her. And she said, what? Yes, he was. Of course he was. I mean, she had 2 babies in the car. He was confronting her. And then she even said, remember? She said, if that was me, I would have been scared in my mind having 2 kids in that car with him walking around doing that stuff. And then he asked you all, would you be concerned? Of course. All right. And there's something else I want to address. Let's talk about law enforcement. And if this was a law enforcement officer, we wouldn't be here. Well, I don't know about Mr. Trevina, but I can tell you Mr. McCabe, the state attorney.
Objection, Judge. Objection. Completely relevant. Arguing facts now.
Well, it's in response to what Mr. Trevina said, so the door's been open, so.
Well, I can tell you, Mr. Rosenwasser and Fred Schaub would be in this courtroom. Because remember, a law enforcement officer's held to the same standard, the same exact standard as any civilian witness when it comes to the law and justifiable use of deadly force. The same exact standard. So let's examine that. Sir, did you see the weapon? No, I didn't see a weapon. I didn't even see his hands. You didn't see his hands? No, I didn't. Well, did he have a knife? No, I didn't see his hands. Did he have a phone? Did he have anything? No. He was backing up. Well, I thought he was running at me. Is that reasonable? Based upon what we saw, is that reasonable? Even that fellow, Mr. Buffington, the expert witness, and we're going to talk a little bit about that testimony. I mean, that guy was incredible. So you ask him a question, what time it is, and he wants to build you a clock. He'll answer it by telling you how to build a clock. Or you ask him what time it is, and he says, well, it's 3:32, isn't it? And he'd say, well, not exactly. It depends where we are. If we're in California, it wouldn't be 3:32. I mean, he wouldn't answer a question to save his life. And then when he did, some of his testimony was utterly incredible. That's all I can say. Incredible. Think about it. Think about it. So Mr. McLaughlin was under the influence of this drug to where it altered his behavior and made him aggressive, because when this occurred, when he knew that he had 2 babies in that car, and his loved one, the woman he spent 10 years with, the woman he met in high school, the love of his life, the reason he works at night at the 7-Eleven,
Objection, Judge.
he's in that store, and somebody says there's a problem out here, I think you might want to get involved, to the store operator. He hears that. He puts down his stuff. I think he might even try to hand the money to the, you'll look at it. And then he didn't run, he walks outside. But guess what? He didn't bring his kid with him. He didn't bring his child with him. His 5-year-old. Well, that's really bad behavior on his part. Are you kidding me? That's ridiculous. Is he supposed to bring his 5-year-old out in the middle of a problem that he's not sure what's going on? But when he gets out there and he sees this going on to his loved one, he's supposed to bring his 5-year-old? He leaves his 5-year-old in the store where there's adults in there. There's the man behind the counter. There's Mr. Castelli. Okay. So that behavior. Okay. That's okay. What about this one? This is good. This is a good one. I like this one. So after he was shot, and it's our position, you know it, we've said it, he backed up and then he was turning to kind of get away. He couldn't go back any further. And he's not going to turn his back to the man with a gun. All right? He turns to go away. He shot, and if he really was going to attack, he would go forward. But he didn't. He kept on going back. And went into the store and died. He was shot in the heart. He died. But no, Mr. Buffington said, well, I think he should have gone to the protection of his loved one. Are you kidding me? Are you kidding me? Think about that. You know, Mr. Buffington needs to put his coat back on and go back to CVS working behind the counter at Spencer Hills.
Objection, Judge.
I'll sustain the objection.
It's incredible testimony. Incredible. He wasn't reasonable because he went out there and shoved the man. He's a man who has a family. And the reasonable thing is to do just that. Protect those you love. Any mother will protect her children. Any man, any real man, will protect a person he loves and his children. And that's exactly what he did. And because of that, he's dead. And they talked about in their opening statement, and they talked about, Mr. Trevina talked about it's one single motion. Yes, it is. And that's the problem, because it shouldn't be. He created the 11 seconds scenario. He did. Remember in their opening statement, the attorney talked all day long about things. Promises that he said, you know, I hope you follow up on that stuff. He talked about the 11-second rule. The 11 seconds that it took. From the time I got here to walk right here, it took me 11 seconds. That is a problem. Because if he had waited 15 seconds, or he had waited 20 seconds, or he had never shot, this would never have taken place. He created the 11-second scenario. He created it. Once he had that gun pulled, it was done. It was over. He was backing up. He was retreating. This incident was done. Mr. McLaughlin would be alive today with his children if that had taken place. He created the 11 seconds. He created the single incident. Once he had that gun out, he should have thought about what he was doing. He talks about the reasonable man and quotes the law and says it's from his eyes, from his observations. 1, 2, 3, 4, 5 people. There's a sixth person here. There's a sixth person sitting right there. It's called the reasonable man, and he has to sit at the defense table because that's the eyes you look through. Is his observations reasonable? Is what he says reasonable? Is it reasonable to say that the man was running towards me? When I pulled the gun out, he was running towards me. Well, what if I told you he was backing up? It's impossible. It's the reasonable person. You know, I could say, well, I shot him because I thought a Martian was coming down with rays and going to shoot me dead. It's not reasonable. What he's saying isn't reasonable. The 21-foot rule he relies on as justification for doing this, and the rule doesn't even apply. The rule doesn't even come into effect. Because the man's retreating, number one. The man has no weapon, number two. And the 21-foot rule, everybody said this, and Mr. Brown's a nice man, but the 21-foot rule is somebody with a sharp-edged object coming towards you. Finally, he admitted, yeah, but it could be a pen. All right. But the bottom line is the misinterpretation by him, because he doesn't understand proper gun procedures, you can't blame that on Mr. McLaughlin. That's not his fault. He's dead because of that. He wouldn't be dead if this man didn't want to carry a gun for 20-some odd years. He's not trained to be a law enforcement officer, so he shouldn't be enforcing parking laws. Law enforcement officers hopefully know how to cope and deal with confrontations and escalation and not getting involved in that type of thing. He's not trained in that. He shouldn't be taking the responsibility of that. The owner of that business told him, I don't want you doing that. He had no business. No business. And he did. He just wanted to F with people. Because if the true goal is to have people leave, he said he was upset. Oh, I can't. They'd leave. Well, yeah. Isn't that what we want? Isn't that what we want? You know, people always tell me, don't retire, don't retire. Well, now I know why. He's been retired since he was 33. You get bored. What am I going to do? Monitor parking lots? You don't do that. I've never been pulled over by a citizen for driving too fast. You just don't do those kind of things. You don't know what's there. You don't know what's behind in that car. You don't know who you're confronting. Another thing I want to address, you know, Ricky Kelly lied. No, he didn't. He didn't hear a gunshot because he was at work. When the shooting took place, he said he came back, he walked by the store, and the police tape was up. And he saw the car. He was out with the trucks. Mr. Tyler works at this business around the corner. He's there at the business. He's the owner, operator. Ricky's out in the truck. He didn't lie. Now you know why people don't want to come into a courtroom and testify. Why people don't want to get involved. That man did get involved. He knew nothing about this case. He knew absolutely nothing. All he knew is he recognized that car. And that car, the man in it, had gotten into an altercation with him. And if you remember, Mr. Tyler said he didn't want to get involved. I talked him into it. And he marched. I'm glad he did. It started in his neighborhood.
Feelings,
It'll
Judge.
be sustained.
It
With no
started-
personal opinions. Go ahead.
It had started in, well, it's quite understandable for him to do that. It started in his neighborhood. I'm sure he felt bad for what had happened.
and he walked along. You know, Mr. Trevina says, well, you know, a lot of people think this and that. Well, that's not evidence in this courtroom. I don't care what some nut, wacko, right-wing guy thinks. His opinion? What matters is your opinion. What matters is what you think. What matters is what you think about that videotape. And every witness that testified said he was backing up. Even their witness, the pharmacist, said he was in retreat. He was backing up. I mean, then we had their testimony today. I mean, Dr. McLean's a psychologist. She didn't even talk to him. What? You didn't interview him? You didn't talk to him? No. I wasn't asked to. Well, do you have to be asked? Didn't you suggest it? Well, she's a psychologist. She's talking about defensive moves. What is that all about? I don't know. But you know, just because a person's called an expert, it doesn't mean that's what they're an expert on. She's definitely not an expert on that. What did she say when asked about that? It was pretty interesting, right? I mean, she said it was a defensive maneuver, the blading. All right, a defensive maneuver. Well, that's what he was doing. I don't know if he was turning so an object less of his body would face the firearm, or was he turning because he wanted to go away from the incident, because he couldn't back up any further. And I think it's his responsibility to assess that situation. I thought he might kick me. Thought he might kick me. Is the taking, you know, take a kick rather than take a human life. Have we gotten to the point where the value of human life is so little?
Objection.
So little. I hope not. I hope you follow the law in this case. Mr. Buffington yesterday, I mean, come on. Really? So what's more reasonable? Going out to protect your loved one, being a man, or going up to a car that you don't know anybody's in and start pointing your finger and walking around or take photos? How reasonable is that? Is that reasonable? Or is it more reasonable to go protect a loved one? By his own words at the beginning, the sanctity of life is so important. That chair that he just moved should still be over there, because that's always seated at that table. He's called reasonable. Reasonable man. The reasonable man is always seated here. And Mr. Trevina kept on saying it's through the eyes and lens of him only. No, it's not. Criminal law course, I don't know where we were at, but we weren't paying attention. It's through his eyes, but it has to be the reasonable man. It's got to be reasonable. So that reasonable man is always here. Don't get confused. As the judge said, you rely on the law. You rely on the law in this case. And the instructions are easy. And guess what else is easy? And truthfully, what else is easy? This case. It really is. If you watch that video, the first reaction you get is, damn, he's backing up. But it only lasted 11 seconds. Well, it lasted 11 seconds because he had it last 11 seconds. It should have lasted longer, because there was no reason to pull the trigger. Remember, Mr. Camerino got up there and talked about 11 seconds? Mr. Camerino got up there and talked about somebody named Brittany Hicks. You're going to hear Brittany Hicks, Brittany Hicks, and Brittany Hicks. We didn't even hear from Brittany Hicks.
It's legally available to the state, Judge. Proper argument, Judge.
All right, well, overruled.
We didn't hear any testimony from Brittany Hicks. Remember, an opening statement, just like a closing argument, it's not the facts. Hopefully I'm telling you everything that came out in the course of this trial. And I can tell you this, we didn't hear from Brittany Hicks. So, y'all...
Comment on the burden, Judge.
No, if you mention her in opening statement, it's fair game in closing argument.
Overruled. Right to remain silent, Judge.
If you mention her in opening statement, it's fair game in closing argument.
We didn't hear from her, but we did hear from witnesses who talked about the altercation. And we heard that it was an altercation at that car. And we've heard from witnesses, he was the loudest of it. He was the loud one. He was aggressive. This is what Mr. McLaughlin would have seen. The finger wagging at the car. What the heck is going on? That's what he saw. Right before he was shot, was shot, this is where he was positioned. Threat was removed. When that firearm was pulled out, the threat was removed. And I'm sorry, again, I disagree totally with the defense attorney, Mr. Trevina. Need to go to that criminal law class again, because justifiable defense of others.
Comment on counsel, Judge.
All right, please don't comment on counsel. You may comment on the evidence in the law. Go ahead.
Justifiable defense of others, coming to the defense of another, coming to the defense of your girlfriend, coming to the defense of your children. That's a complete defense. Mr. McLaughlin wouldn't have been charged with any crime, even though he wants you to think he would have. He wouldn't have.
Overruled.
He said, this is an aggravated battery. He said it, not me. No, it's not. It's a defense of others. He came to the defense of others. Under the circumstances he found, did he act reasonably? You saw every person that came into that store look at that direction of the confrontation. Every one of them looked towards that confrontation. That tells you how loud it was. Mr. Castelli came into that store and said, there's a problem out here, you need help. What type of man wouldn't go out there to do that? Not much of one. May I have a moment, Your Honor? The defense talked about, one minute they talk about we put on some show, putting these witnesses in. This was a pretty efficient trial. It went pretty quickly. And we put evidence before you that we thought was important, evidence that was relevant. I told you at the beginning of the trial that we wanted you to be at that scene as much as possible. I hope we did that. But, he talked about on one hand, a bunch of foolishness, but then he wants to mention that, I don't know why, but he wants to mention that the slug, he wasn't able to make an identification of the slug from the gun. Well, because he said there wasn't enough markings, but what's that matter? Are we saying he didn't shoot? No, of course he did. So they're making fun of what we did, but yet they're questioning some of the things that came out that they think is foolish. I didn't understand that too much.
Sustained. No personal feelings.
There's been a lot of talk about the slow motion. And we want you to believe he saw things in slow motion. No, we're not saying that. We're not saying that at all. That's why we played the full motion, inside the store, outside the store. We played full motion the whole time. We have a snippet, a very small amount of time that we have a slow motion. And yeah, a referee doesn't lie, and I'm not saying he lies about that, but the man wasn't moving forward, that's obvious. But you know what? When a referee in a football game makes a mistake, it doesn't cost someone their life, right? It doesn't. I mean, some football fans might think it's important, but it doesn't cost anyone their life. And even a football referee, if he makes too many mistakes, he loses his job. But this fella made a huge mistake. tremendous mistake. In his own words, his very own words in this case, was, if he had been backing up, would you have shot him? That was asked of him. And he said, no, of course not. That wouldn't be a good shoot. If he was standing still, would you have shot him? He said, of course not. His own words tell you he's guilty. Because the reasonable man, that fellow sitting right here, it's obvious that he was backing up. He wasn't moving forward. He wasn't running forward. Scott, can you come for a second? Remember their testimony today from their witnesses. This is what he saw. Oh, I'm sorry. This is what he saw. And those witnesses tried to tell you with a straight face that that was an aggressive stance. That's what caused someone's life to be taken. I would hope we would never have to charge a law enforcement officer for that.
Objection.
Sustained.
Not seeing his hands, not seeing his face, never hearing a word said. That is what caused another human being to lose their life. The last thing I wanted to mention to you is, you have the verdict form. Thank you, Your Honor. The law, just real briefly, I'm going to sit down, but first of all, this is not first-degree murder, it's not second-degree murder, it's manslaughter. The unlawful taking of another human being's life without legal justification. Legal justification. Follow the law. Follow the law in this case. It's not, we don't have to show that he intended to kill. What we have to show is that he intended to shoot his gun. He intended to shoot his gun. He had his wits about him. We know that. Vicki Conrad said, remember? She said, he seemed fine, he seemed coherent, he calm after this, but he felt calm. She even said proud. All we have to show that he intended to shoot that gun and someone died as a result of it. One of the things that you're going to have on this that we failed to mention, we, the jury, find as follows: the defendant in this case is guilty of charge of manslaughter as charged. And then there's something in here that the defendant carried, displayed, used, threatened to use, or attempted to use a firearm during the commission of the crime. And it says yes or no. So if you found that a firearm was used by the defendant, if you find he's guilty of manslaughter, then you've got to say, was a firearm used? If you find that a firearm was used, then you check that box, that it was used. Yes, it was. All right? One of the things that, I'm sorry, Your Honor. One of the things that defense counsel had mentioned, and is his life and his liberty, his life and his liberties at stake. Years ago, he's dead now, but a prosecutor used to make this argument, and I thought, man, that's a really good argument. And it was, if in your mind you're wondering, what a sentence might be, then in both your heart and your mind, you've already found him guilty. Think about it. That cup that was put before you that has to be filled up, that cup runneth over. I don't know what substance was being put in that cup, but if it was sand, it's clearly out of that cup and on the floor now, that reasonable doubt thing. It's been 13 months. 13 months that this happened. And today, in this courtroom, we've completed our case. You've heard the argument, you're going to get the law. We told you one of our goals was to ensure that he has a fair trial. You see now how our court system works. He's been given his fair trial. He's had this presumption of innocence for 13 months. Now, we're going to ask that you take that from him. You take that presumption of innocence away. And you bring justice into this courtroom with a verdict of guilty. You consider the evidence. Follow the law. Apply that law to the evidence. And then come back into this courtroom and speak the truth with a verdict that says, we, the members of this jury, each and every one of us, all 6 of us, we find you guilty of the crime of manslaughter. So say we all, each and every one of us. Thank you.
All right, members of the jury? Okay.